Let me ask you, Director, did any uncleared individuals receive any classified information over Hillary Clinton's server?
Did any uncleared people receive classified information? I don't think any of the correspondence on the classified emails were uncleared people. These were all people with clearances working, doing State Department business on the unclassed system.
Did Mr. Pagliano have the requisite security clearance?
As I sit here today, I can't remember. He was not a participant on the classified email exchanges, though.
But he was running the server. He set it up.
That's a different question. I'm sorry, I misunderstood your question then. Yeah, there's no doubt that uncleared people had access to the server, because even after Pagliano, there were others who maintained the server who were private sector folks.
So there are hundreds of classified documents on these servers. How many people without a security clearance had access to that server?
I don't know the exact numbers. I sit here. It's probably more than 2, less than 10.
And I appreciate your willingness to follow up with this. Did Secretary Clinton's attorneys have the security clearances needed?
They did not.
Does that concern you?
Oh, yeah, sure.
Is there any consequence to an attorney rifling through Hillary Clinton's emails without a security clearance?
Well, not necessarily criminal consequences, but there's a great deal of concern about an uncleared person not subject to the requirements we talked about in the read-in documents potentially having access. That's why it's very, very important for us to recover everything we can back from attorneys.
So what's the consequence? I mean, here, Hillary Clinton gave direction to her attorneys without a security clearance to go through documents that were classified.
Yeah, I think that's what happened in fact. Whether that was the direction is a question I can't answer sitting here.
So you're parsing that one a little bit for me.
No, you were just asking me. I don't
What's
know.
the consequence? They don't work for the government. We can't fire them.
Right.
So is there no criminal prosecution of those attorneys? Should they lose their bar license? What's the consequence to that?
Well, if they acted with criminal intent or acted with some malintent.
What you're telling us is it doesn't matter if you have a security clearance or not. Because I may be innocent enough, hey, I'm just an attorney, I like the secretary, I'm trying to help Hillary Clinton. I'm not trying to give it to the Chinese or the Russians, I'm just trying to help her. So there's no intent? It doesn't matter if these people have security clearances?
Of course it matters. That's why I said that.
But there's no consequence, Director. There's no consequence.
Well, I don't know what consequence you'd have in mind.
Prosecute them.
An attorney for receiving from his client information that ends up being classified.
I asked you at the very beginning, is there a reasonable expectation that Hillary Clinton would send and receive, if not daily, hourly, if not daily, classified information? That's reasonable to think that the Secretary of State would get classified information at every moment. She's not the head of Fish and Wildlife. So the idea that she would turn over her emails, her system, her server to what it sounds like up to 10 people without security clearances, and there's no consequence. So why not do it again?
That's a question I don't think you should put to me. You're asking, I'm talking about my criminal investigation.
But how can that, there's no intent there? Does she not understand that these people don't have security clearances?
Surely she understands at least some of them don't have security clearances.
So if she understands they don't have security clearances, and it's reasonable to think she's going to be in classified information, is that not intent to provide a non-cleared person access to classified information?
You're mixing it up, though. I don't think it's reasonable to assume, mixing me up, sorry, it's not your fault, that someone who is maintaining your server is reading your emails. In fact, I don't think that's the case here. There's a separate thing, which is when she's engaging counsel to comply with the State Department's request, are her lawyers then exposed to information that may be on there that's classified? So,
and did they see any classified information? Did Hillary Clinton's attorneys, without security clearances, see classified information?
Sit here, I don't know the answer to that.
It has to be, yes, Director. You came across 110, and they said they went through all of them.
Well, they didn't read them all. They just looked at headers.
So their excuse is, we saw the emails, but we didn't read them?
No, I think I said this in my statement on Tuesday. They sorted the emails by using headers and search terms to try and find work-related emails. We read them all.
I know that you read them all. Do you think it's reasonable or unreasonable to think that her attorneys, under her direction, did or did not read those emails? Because there were, let me go back to this, yes or no. Were there or were there not classified emails that that Hillary Clinton's attorneys read?
I don't know whether they read them at the time.
Did Hillary Clinton give non-cleared people access to classified information?
Yes.
What do you think her intent was?
I think then was to get good legal representation and to make the production to the State Department. I think it'd be a very tall order in that circumstance. I don't see the evidence there to make a case that she was acting with criminal intent in her engagement with her lawyers.
And I guess I read in criminal intent as the idea that you allow somebody without a security clearance access to classified information. Everybody knows that, Director. Everybody knows that. I've gone way past my time. Mr. Costello, electronic records fall under the jurisdiction of the Federal Records Act, correct?
Pardon me.
Sorry.
It's okay. Yes, they do.
Mr. Linick, do you believe, I'm going to ask you both questions, so go ahead and say. Does this include, so electronic records fall under the jurisdiction of the Federal Records Act, right, Mr. Linick?
So long as they contain work-related materials, yes.
Does this include video?
Well, if you're asking about the videotape, the separate issue, I mean, that's something we're looking at, and we're really not able to comment on that at this time. I mean, that's an ongoing matter. Whether videos are records, but we're looking at that issue.
Is this relating to the 8 minutes of
Right.
deleted videos?
Right.
So the Inspector General is doing an investigation.
Well, we've started a preliminary review, and we've looking into that matter at this point. We have not opened a full-blown investigation, but we are looking to see sort of what the issues are, and we've interviewed some people.
Well, we also have a jurisdiction, and we would like to know. So my question is, if the electronic record is video, is it treated differently than if it's text?
I'm not able to answer that question. I mean, that's
Why
outside
not?
the scope.
Why
because
not?
I don't have an answer for you. Again, we're sort of in the middle of looking at those issues. It's not part of the report that we issued.
Right.
And I can only talk about what my work supports, but
So if
I wouldn't
the-
want to venture a guess.
If the personnel are paid by the federal government, the hardware is paid by the federal government, the software is paid for by the federal government. If somebody were to tamper with that information, is that a violation of the Federal Records Act?
I mean, a federal record can be contained on any medium, so potentially it could be a record, potentially. In the case you're talking about, there's a transcript and a video, and it's unclear which is the federal record. So that's why I'm hesitating here. But a federal record can be on any. It could be on a napkin.
Could they both be?
Again, I'm not sure, and I don't want to get into that.
When will you give us that answer?
Well, we're working on it. So we'll.
No, but I want to know what's reasonable to know when you're going to get back to us on an answer on that.
You know, I will talk with my staff who's doing that work and get back to you and let you know sort of where we are.
You'll get back to me when?
I'm happy to get back to you as soon as I get back to the office and let you know sort of what's going on.
By the end of the week, is that fair?
Sure.
That's tomorrow. So.
Sure.
That would be most helpful. And I do think it's affecting the federal record. And I think you need to look very closely at that. Something we're looking at, and we need your input and your professionalism in saying, to me, it's pretty clear. These are all records, whether they're video, transcript, there may be photos. certainly if you are involved in law enforcement, the more of that you have, the better the situation. And we do this differently than most countries. We do preserve records, and we do allow public to access this information because they paid for it. It's their government. That's what the Freedom of Information Act is all about. And when things are there and then deleted on purpose, then there's a cloud of mystery that needs to be rectified, and I look forward to hearing back from you. The emails, the classified Hillary Clinton emails, can you provide us those classified emails?
Well, we didn't look at the classified emails. I mean, that wasn't part of our review. I mean, maybe Mr. McCullough can answer that question.
Certainly, I can provide you what, and I believe we have provided Congress with everything that we had. We can certainly, it's over in Senate Security. We provided it to SSCI, I believe, and HIPS.
Can you provide this committee in a secure format the classified emails?
What I can, to a certain extent. I cannot provide a certain segment of them because the agency that owns the information for those emails has limited the distribution on those. So they're characterizing them as ORCON.
Explain what ORCON is.
Originator control. So I can't give them to even Congress without getting the agency's permission to provide them. So they have been provided.
Which agency?
I can't say that here in an open hearing, sir.
So you can't even tell me which agency won't allow us as members of Congress to see something that Hillary Clinton allowed somebody without a security clearance in a non-protected format to see. That's correct?
Yeah, this is the segment of emails that this is why my letter back to Ranking Member Cummings had to be classified, because people would like to see this segment of emails. And this has been an issue not just with you and your committee, but with several members at this point. So we have gone back to the agency that is involved several times, and we can certainly do that again and ask permission.
Can you generally tell me, is it because they're so sensitive about signals intelligence, humans intelligence? What?
We shouldn't get into the content of these emails in an open hearing, but I'd be happy to take it.
I don't want to violate that, but the concern is it has already been violated, and was violated by Hillary Clinton, and it was her choice. She set it up, and she created this problem, and she created this mess. We shouldn't have to go through this, but she did that.
This is the segment of emails that I had to have people in my office read in to particular programs to even see these emails. We didn't possess the required clearances and compartments.
So even the Inspector General for ODNI didn't have the requisite security clearances.
That's correct. I had to get read-ins for them.
Unbelievable. What a mess. I'll yield back.